case briefs, and so much more. LSData's got what you're looking for.
In 1958, the United States District Court for the Southern District of California ruled in the case of Trenton Industries VAE Peterson Manufacturing Company, where a high chair invention was at the center of a patent infringement dispute. The case focused on the rule of reason in determining if the defendant's structure fulfilled the pivotal function of the patented invention, as well as the principle of unjust enrichment, which addresses the use of another's invention without permission before a patent is granted. The plaintiff, inventor of the high chair, accused the defendant of using the invention without compensation before the patent was issued. The defendant claimed the patent was invalid and that there was no infringement. Upon examination, the court found that the alleged new feature in the plaintiff's high chair was already known in earlier patents. Despite this, the court found that the defendant's chair was not so similar to the plaintiff's that it constituted infringement. The plaintiff also claimed unjust enrichment, arguing that the defendant used the invention without permission. The court decided to address each count separately and ultimately ruled that the patent was invalid, but the plaintiff could still recover damages for unjust enrichment. The defendant was ordered to pay a reasonable royalty for using the plaintiff's design without permission. A special master assessed the damages, and the plaintiff was awarded its costs.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.